3 seconds. Yes. Okay, Olga. Well, thank you very much, Olga, for taking out time. And it's very nice to have you as a speaker. If you could just introduce yourself and please take it forward from there.
First of all, thank you very much for inviting me. This is a unique moment for me, and it's a really honor to be among you and my really esteemed colleagues that I can see. Hello, Giovanni. Good afternoon. Good afternoon, good morning to some attendees, and good evening to others, because we are living in this digital global world. So who am I? I am Olga Tsiptse. I am from Greece. I am, as you can see, can you see my screen? Yes?
Yep.
Is that right? Yeah, okay. Yeah. I am an LLM lawyer at Supreme Court of Greece. I am a mediator, accredited mediator and arbitrator of Ministry of Justice here in Greece. And I am a data protection officer in some entities in Greece, and chair of European Data Protection Association, Data Professionals of Data Protection Association. I'm here to speak about mediation in Greece, that I really think that it's, as I say, mediation in Greece is a modern Iliad, because there are many things that have been happening all these 10 years from since the first year, the 2010, that the first mediation law was first appeared. You see my screen, is that right? Because I don't see myself at all. Do you see my screen?
No, we only see you.
No, only?
Yeah, it was I mean, we could see it now, we don't.
Okay, sorry. Wait a minute to share again my screen. I think that you can see that.
Yeah, just about, yes, yeah, it's there, and it's, yes, okay. Yeah.
Well, as I said before, I consider mediation in Greece as a modern Iliad, because many things have been happening all these 10 years. So this is a case. I consider this lecture, this session, as a case study, because it's really interesting to see what is happening in Greece, and to use this information in order to avoid some obstacles, or to take some recommendations for best or worse practices. In Greece, we have some recent development. In fact, we have a new law in 2019 that amended the first law of mediation. But before that, new law that was issued 2 years ago, it was another, a second mediation law that was issued but never came into force because of the tractions and the reactions of the lawyers and the judges that that law caused. As you can see, we had the first appearance of institution of mediation in Greece in the year 2010. That law was 3898 of that year, 2010, and that first mediation law ratified the EU directive, European directive of European Commission, that was 2008, and the number of this directive was 52. You can see that the first law was in fact a translation of this EU directive, and it was some other provisions included from the Code of International Conduct for Mediation, so the Code of Ethics. A second effort was for mediation law was in 2018 that amended the first mediation law, but as I said before, never came into force. And of course, in that year, one of the innovation that we will speak in a minute about this, the innovation was the mandatory mediation, or at least the mandatory effort for mediation, first effort for mediation. And the third law that is in force right now is the law 46 and 40 in the year issued in the year 2019. And again, we are speaking about a mediator, mandatory first or initiative mediation session that is called MIMS in short, and it's only for some cases, family cases or torts, the articles 5 up to 7 of the new law. We will speak about this in shortly. So you can see that all these years in Greece, we have, like in many other countries, European countries, we have been facing for a long time a deep economical crisis. You can see that in Greece we have economical crisis since 2008 up to now, and after that we had this health crisis with COVID-19. And through all these years, Greek citizens experienced numerous of difficulties. There was a huge taxation policy, and it was really exhausting for the citizens because they couldn't afford all of this that was happening, even the wealthy one, not only the citizens that were not wealthy. So for many citizens, it was a necessity to be incentives, and for businesses, of course, who were in troubles with loans that couldn't pay, and all these things that happening in the taxation. There should be incentives for businesses, for investors, and for self-employed employees. So what is the connection between economical crisis and mediation? The key element for a community, a country to be a successful country and to have investments and businesses and all these things is that justice shall be quick, shall be very easy to be accessed. And I think that the way that justice runs into my country, I think it's really disappointing, because we have, if we decide to go to court for a resolution of a case, of a dispute, we have to spend a big amount of money, and of course up to 8 years or 10 years to resolve a case. So this couldn't be happening for many years, because we have now this resolution institution that is called mediation, and we can see that the huge advantages of this institution is that it's not so costly, and it's not so time it's time effective. So there had to be a change in favor of the citizen, at least in justice, and that would be a good motivation for broader change in many other fields. So this new law of mediation could be a positive start for changing of culture. The changes that brought the new mediation law in 2018 are milestone for the promotion of a complete and out-of-court dispute resolution system, and that promotion would finally achieved because for the first time the sense of mandatory mediation was finally into force, because as I said before, 1 year before this last law, mandatory mediation was not approved. So we're speaking about mandatory, of course, initiative mediation session, not the whole procedure, because the mandatory in the whole procedure is against the Constitution of Greece. And it's not for all cases, it's only for a very limited amount of cases. So it was a high time that mediation could be widely known, because up to now almost no one knew about this institution, neither lawyers nor judges nor citizens. They were not aware of the institution. And it was good to know that it's a famous and productive procedure, was cost and time effective, and that was mediation. And the reason why mandatory mediation is so important is because it couldn't be famous if it wasn't mandatory. I mean, lawyers doesn't choose to select or to propose going for mediation because they think that they are going to lose clients choosing and having selected this institution. So if it's mandatory, then they should select that. They should and they would select that. So that's why now everyone knows about mediation. And before that new law, nobody knew, though the previous mediation law was counted over 10 years. So the globally, you know that mediation is globally promoted, and we can see that because Singapore Convention was issued that year and was signed that year in 2018. So we can see this effort, globally effort for promotion of mediation. And this promotion aims the citizens will be informed and have the ability and the access and can access this quick, easy, economic method of dispute resolution. That is important because many citizens gave up efforts of claiming their rights up to now. You see, if you have in Greece, if you have a claim for up to 500 euros or 1,000 euros, nobody goes to court because they think that they will spend more money to claim this small amount. So they don't bother going into court procedure. So they lose money. But in mediation, that doesn't happen, because we can see that in one day and with so little expenses, they can claim their. They can proceed this dispute resolution and can be the owner of their claims. So you, I think that I have to change also. Mm-hmm. So let's start from the beginning, from the European Directive of 2008. The number is 52, as I said, that was ratified in Greece with the enactment of the law 3898 of the year 2010. And this law introduced for the first time the concept of mediation as an alternative way of resolving disputes in Greece, but also in cross-border disputes arising between human and legal personalities between at least two countries. That is called cross-border dispute resolution. Unfortunately, at that time, civil and commercial mediation couldn't deliver the expected results, mainly for two reasons. Because mediation is a voluntary institution, so no lawyer or judge was willing to introduce or to suggest the peaceful method to his or her clients, as I said before, because no lawyer was willing to learn about mediation, and everyone was familiar to this classical and court practice procedure. So this uncertainty of these economical years and the fear of losing clients led judges and the lawyers not to select mediation. And the second reason that mediation was not successful up to now as an institution was because there were no incentives in the application and the selection of this institution. I mean, we can see in England, for example, we have some economical incentives for the players of a dispute, and before going to court, you should choose a mediation for resolving disputes, because if you do that, you can earn you can have some economical incentives that you may lose if you go to the court directly. So these things we never had in Greece, and the mediation was really not promoted at all. The numbers of concluded mediation in Greece from the years 2010 up to 2018, these 8 years, was really a disappointment, because we had almost 10 years mediation law in force in Greece, and we had only up to 50 or 60 cases of successful mediation procedure, and that was a disaster, as you can see. So this great failure of institution was because there was no willing of using this out-of-court method. There was no trust, no awareness, nothing at all, and such a very useful instrument that was offering for resolving so many problems was almost abandoned without having any chance for through practice. Some changes to the first mediation law had to be occurred, and indeed these changes came with the first amendment of that first law in 2018, and as you can see, it was of course the mandatory mediation. One of the greatest mediation advantages is that the majority of the cases that going through this procedure are having a very successful outcome in Greece, at least. And this leads to a common accepted settlement of the dispute. You can see that mediation has started to working. The academics who examined this application of mediation and it's called the Central Mediation Commission of the Ministry of Justice here in Greece, they proceeded a research about the evaluation of institution of mediation, and they wondered strongly why mediation was inactive in Greece all these years, through considering the results of the mediations that were really, when you choose mediation as a procedure, the results and the settlements are very successful, and we can see this diversity. You don't choose something that is very successful. So the academics examined why this happening, why we don't choose something that certainly ends to a successful settlement. And of course, there is no answer for that. Only the thing that it's not mandatory. That is the conclusion, that mediation was not selected. I'm sorry, I have to change the slide. Why is not changing? Oh, I'm sorry. Yes, okay. So, as I said, in 2018, there was a new second mediation law that tried to amend the first mediation law, and the Greek legislature tried to transfer the above need for change of culture and the mediation promotion movement for civil, commercial, and family cases. And that was strictly based upon mandatory proceedings, because that was the problem of mediation. It wasn't mandatory, so nobody could choose. Of course, we could not select a system that would promote mandatory mediation in Greece, because it is against the Greek constitutional right of the citizens to appear before the nature justice. It's the Article 20 of Constitution of Greece, and since all citizens have the right to appear before a natural judge, we cannot exclude court procedures. So we could not have a mandatory, directly mandatory mediation, because that would be unconstitutional. The first effort to transform the voluntary mediation to somehow mandatory was held in January 2018 through the article of the law 4512 of that year, through the article 182. And this obligation was consistent to the below key points. Before the in-court discussion of a case, the parties were obliged to try to resolve their dispute through mediation. If the parties wouldn't pass through that phase, the penalty was that the claim would be considered and would be judged as inadmissible. So the claimant would lose the case for typical reasons. And the provision was not for every case. Not every case would have this mandatory phase, but it was only for limited cases. And these cases are where disputes between the owners of intangible assets, disputes concerning claims of car damage, but after a car accident, but only if damages were only to the car and not personal injuries or deaths. Disputes for fees through the Greek professional fees, through the Greek procedure code, and fees from offering professional services. Family disputes except from those that are not mediatable. Divorce here in Greece is not mediatable, because if you want to issue a divorce, you have to go to the court or to a notary, not to mediation. It's not allowed. And disputes concerning claims for compensation of patients, disputes arising out of infringements of trademarks, patents, and in general intellectual property, and disputes from stock exchange contracts. These were the disputes that could be, should be, and if it was their mediation procedure, the claimant would lose the case for typical reasons. Though the law was a really groundbreaking change for the law of mediation, contributing the great establishment of mediation and huge innovations about this mandatory obligation, there were strong reactions. Very strong reactions. I think my friend and the colleague Giovanni Matteucci, who is from Italy and has experienced the same reactions in his law. I think that he's aware that the reactions, these strong reactions, came from lawyers and judges, because the lawyers were afraid of losing cases, and the judges, of course, thought that the mediation would be private justice would be privatized, and that was not good for them. So the most here. Here you can see in the slides that were thunderous arguments against the implementation of mediation law of 2018, and the arguments against mandatory mediation was that first of all, mandatory mediation is contra its nature, because mediation means freewheeling and voluntary procedures. And this voluntary participation of the party is the precondition of the proper mediation proceedings. Okay. The second reason was that compulsory mediation jeopardized justice, and there is a risk of justice privatization, keeping the citizens apart and really in distance from their natural judge. That's really not true. Mediation is responsible for lawyers' loss of clients. Also not true in practice, I mean. And it opposes Article 20 of paragraph 1 of the Constitution of Greece, according to which it's defined that everyone has the right to be provided with legal protection by courts before their natural judge. So this was the arguments against the mandatory mediation, but there were some opposite arguments that from supporters of mediation that said that mandatory phase of an out-of-court effort would be only an effort and not a complete procedure of mediation. That means only in the first initiative session and not the whole procedure. If any party wanted to end the proceedings and go to court, she or he would be free to do it. And the effort would be a low-cost procedure and quick in time. That means that this session could not be used by the one that didn't want to go to court in order to delay and in order to make expenses work against going to court. That was the reason for that. And all these strong reactions caused the suspension of that law twice. We had a law for mediation suspended 2 times. And finally, the law was amended before getting into force. So in 5th of July, 2 years ago, we had elections in Greece, and there was a change of political field, and the new government passed immediately after being elected this new and in force finally a law of mediation. And this is the law 4640 of 2019. And was unanimously approved even by administrative session of Supreme Court, because Supreme Court had said that the previous law was against Constitution of Greece, and then this new law said, Supreme Court said that it's okay, so we can use it. And so we can see that this law came into force into a great timing, because modern trends have showed that we live in a globalized environment, that individuals and businesses are moving fast at the same time, are moving efficiently. So there are great expectations for also in the field of justice, that the disputes that arise must be resolved in the shortest possible time and at the lowest possible cost. For example, if you are an investor and you want to make a profit from your investment in Greece, you wouldn't select Greece, because the system here not only taxation and all these things, but also the system, the justice system is not very good. But if you know as an investor that you have a country that has a justice that really is effective, so that would be an incentive for an investor to invest in that country. I would like to have, yes, this is what I said. I have just said, and I would like to have a quick overview on the new law that is in force now. Because okay, what happened has been happening all these years, it's over. So we have finally this law, and we have to know what is all about. What is the new law about? Mediation is globally considered, as we said, as a popular institution, and now we are seeing that some entities here in Greece and of course, the Ministry of Justice have decided to promote this institution. I would say something. Going back to the book, Getting to Yes, that it's the Bible of mediation, I think. Parties usually stuck into their positions, and that is wrong, because a position can be easily changed, and they are not interesting for their interests, though they should be, either because they don't know what are their interests, or because they cannot recognize them and divide them from their positions because they are confused. So mediators have this exactly duty to help to educate their parties and to train their parties to recognize their interests and their needs. And this is something that the Ministry of Justice in Greece has really recognized to mediators. And that's why they changed some things about mediators training and mediators lifelong education. So in Greece, a mediator has to be accredited by Ministry of Justice, and that means that the mediator shall participate to an 80 hours compulsory course, and he or she has to pass exams to this training entity, and after having passed these exams, also has to pass exams oral and in writing of the Ministry of Justice. So it's really hard to become an accredited mediator here in Greece. We have to study a lot. No legal background is necessary for being a mediator, but the candidates must retain a degree of higher education. After achieving all this, mediators can take a number of registry and are listed to the mediators catalog of the Ministry of Justice, and can be selected for every civil or family or commercial mediation. Mediators must attend to a lifelong mediation learning programs every 3 years. We have to complete some hours every 3 years in order to retain our license. So we have two kinds of mediation. It's the voluntary mediation for any civil commercial case, apart from those who are not mediatable. And one more kind is, as I said, mandatory, but not the whole procedure. Mandatory first initiative session of mediation. That is called in short MIMS. And in this second case, the compulsory stage of mediation is limited only to one initial session. We cannot have second or third, or it's only one for some time, 1 or 2 hours at the most. And if parties don't want to continue to mediation proceedings, they are free to move with court proceedings. I will say something about this session in shortly, because in my experience, this session is, I can say, speaking, having experienced in many cases this first initiative session is a disaster for mediation. But I will say why I consider this new provision as a disaster. So due to the new mediation law, this mandatory initiative session of mediation applies for limited cases. It's only for here. It's only for family cases, apart from those marital disputes that cannot be mediated, such as divorce, recognition of existence or non-existence of marriage, parent-child relationships, regarding infringements of paternity. These are the things that cannot be mediated, so cannot have this procedure of means. Second case is the claims disputes with price over 30,000 euros. If you have a claim over 30,000 euros, you have to have this initial session of the mandatory initial session, and the disputes that originated from contracts where there is a written mediation agreement. So that means a valid mediation clause. And the procedure and the enforceability of mediation agreement in Greece is the following. A minute of successful resolution is drawn up with, and this record, these minutes, can be submitted by any of the parties at any time they want to the registrar of the court of first instance at the place of the dispute. And with a low cost of 50 euros, we have the paper that is in fact enforceable for our claims. It gives us enforceability for having our claims, for conducting our claims. And the mediation procedure is described in the articles 5, 6, and 7 of the new law. This is the mediation procedure in these articles. And there are some written formalities that must be performed. And if these formalities are lacking, the case will be lost for typical reasons. And if the parties cannot choose for a mediation procedure a common approval mediator, then there is a central committee of Ministry of Justice that appoints a neutral third, and there are time limits for mediation because we cannot have this procedure forever. There are some time limits that are described in this law. And now I will say some things about, sorry, sometimes I cannot, okay, no, I don't have any slide. I want to say now about this, my thoughts about mandatory initiative mediation session, because I think that this MISM is a disaster for mediation, and it's a personal opinion that is, it's from my experience. I think that this session causes harm to mediation, because in practice, the cases that close this obligation, this MISM obligation, lead mediators to be underestimated, because they are the one who have to call the parties, seek for the mutual agreement to their personality, I mean to their appointment as mediator. So they are calling the parties, and they are saying, do you agree that I could be your mediator? It's not the way that it should be. A mediator is not a seller of himself, is a professional that has to stands really high, and not to seek for approval. This is the job that the parties should do. And also in this MISM procedure, mediators do plenty of bureaucracy. They have to send a great amount of documents in order to start this 1 hour session, mandatory session. And all this procedure is really without any justification, only to book a small appointment of 1 hour, and where parties and their lawyers already know what they want to do. So I think that it's really wrong about mediation. It's not the way. Of course, if you find some time to explain to the parties and the lawyers what is mediation all about, it's okay. But imagine now that, let's say in family cases, we can see that there are two parties that really have many issues to resolve. They don't want to hear a mediator to say good words about mediation. This is what lawyers should do in order to help the parties select this institution. But when we read to a mediator, we really, I think that it's underestimated explaining to the parties what is right and what is wrong about this institution. I think that we are losing our personality and our position, let's say, in this procedure. So I think that the procedure, this mandatory procedure, small mandatory procedure, is very demanding, because the claimant usually submits a request to a mediator for initiative mandatory session. Mediator seeks for approval for his appointment from the other party. And in case of disapproval, the one who claims this initial session has to go to the Central Commission of Ministry of Justice and ask for appointment of a neutral, third neutral from Ministry's registry. Lots of work, lots of procedure for 1 hour mandatory session, and lots of documents, as I said before. So I think that with this mandatory session, mediation is famous now in Greece, but I don't think that famous is something that should seek at least we as mediators. So having all this said about these three laws in Greece and how the obstacles bothered mediation and put mediation in the second or third selection, and really parties prefer to go to the courts instead of having these procedures. I want to say something about mediators, because I think that mediation's key point is a qualified mediator. And I think that a qualified mediator is a conclusion of several things, of experience, of again, I take some notes from what Giovanni Matteuzzi has written about mediators, because he says very good things about us, and he says that mediators are not only well educated, are not only the talented, have to be experienced, have to know about cultures, especially about cross-border mediations. They have to know cultures, they have to know diversities, they have to know everything in order to do their job well. And I think that as I write in the slides, there is no mediation if there is no mediator, but also there is no successful mediation if there is no capable mediator. And capable means many things, not only education and experience and talent and everything. So through mediators' special mediation techniques, on which is initially trained but also continuously retrained, is called upon to communicate effectively with the parties who have the dispute. The mediator has to establish trust, communication and trust. Mediator does not guide the parties, at least in Greece, does not propose solutions, but is only there to hear. Here in Greece is only that kind of mediator. We cannot propose, we cannot guide the parties. We hear them, and we are trying, being the devil's advocate. The devil's advocate. We are trying to show to the parties that what they think that is their interest, maybe not their interest, and maybe only their position. So mediator has to listen to the parties, to observe them, or everything, eye contact, body language, everything. Mediator has to show sympathy or empathy for the parties, helps them to realize the real problem, and this problem may be caused by several and various factors. And of course, one of the greatest factors are psychological factors. So they have, because we are all humans, and we have to seek for these reasons of creating disputes. Mediators help parties to see their real interest and cut them off from their positions. And in Greece, there is not yet any reference to specific skills that a professional in mediation has to obtain. But in training programs, there is a small familiarity to these skills. After this training sessions, every professional has to seek for their own development and their own evolution about knowing skills and knowing cultures and knowing all these things that may help him or her be a good mediator, good professional. And of course, there are many international institutes and universities and entities that Greek mediators attend, mostly online, because they want to catch those skills and methods and ideas. In Greece, we have 5 mediators institutions: in Athens, which is capital of Greece; in Thessaloniki, my city, which is the second biggest city in Greece; and in 3 other cities. And we are having programs, training programs from Italy, from England, from the Netherlands. We don't have any Greek program yet, but of course, sometimes it's in English, sometimes it's in Greek, depending on the trainers. And after that, we have to seek for training entities, international training entities, to move forward. As I said, we never stop being trained, and we never stop being evaluated, because only mediator can help mediation to success, or can help mediation to be a failure. And I think I can close by an allegory of Plato's allegory. Imagine a group of people, Plato, the Greek philosopher, because as a Greek I have to refer to him. Imagine a group of people who live in their own in their whole lives being chained to the wall of a cave. I mean, they look only to the wall. They are chained. They are not free. They are chained, and they look only to the cave in such a way that they look in front of them and in an empty wall. No other direction. These people can only watch the shadows of the wall. I mean, if something is happening behind them, they can see only the shadows in the wall. So these shadows are formed by the objects that pass behind them, and they think that this is their reality, the shadow, but it's not their reality. The shadow is not their reality. They don't know that. They don't know that it's not their reality. They believe that this is the reality, and they really keep watching this shadow. Finally, this is the role of a third neutral, of a mediator. She or he, a good mediator, is called upon to untie these parties, to unchain them, and to open their eyes and help them to see that the shadows is not the reality. And these bonds that the chains, in fact, are their positions. But as I said, their positions may be changed. So if someone unchains their position, there may be something else in the future. So the real aim is to find out the interest against the position. And that's from me. I think that I have I have told this too much. I don't know if you are if I have.
No, thank you, Olga. It was very nice. The only thing is, I didn't ask you, what about those fires that were taking place in Greece? Have those fires stopped? There were some major fires.
Fires. I'm sorry. Yes, we had fires in many places in Greece. In Athens, in Evia, it's an island near Athens. A lot of harm has been occurred all the summer. Almost 20 days we have huge fires, but now we don't have any. But the people who live in these areas are really not so good economically, and really their some professionals have lost their jobs because it was strictly in the forests, and I think that the damage is very, very big for Greece.
I'm sure, yeah. But when I saw those pictures, it was quite serious, very serious, the situation. But
yes.
But Olga, all this, you've told us about mediation. We talked about mediation and the court system.
Mm-hmm.
Is there mediation beyond the court system?
Mm-hmm. Sorry, can you? I heard you in gaps. Sorry, my connection.
Is there mediation outside the court system, as we call private mediation? Is that happening?
Yes, it's private mediation. It's not in court. Of course, there is procedure for court mediation, but what I have said up to now in this session is only about private mediation, not in court, during and conducted by judges, because there is also that kind of mediation here in Greece, conducted by judges and doing in court, but it's not very successful either. And the judges are trained differently, not like the mediators for a private system of mediation.
No, but I'm just thinking that we are connecting the matters which are in court or have to go to court. Those matters you should go, it's mandatory to go for mediation. But what about those people who don't want to go to court? They're just their disputes that they have. What about them? Is there any law governing that, or is it in the sum?
If you don't want to go to the court, you don't, and you are a party, you have to be aware that there is also another procedure to follow. And I think that in Greece, up to now, the parties were not aware about having any other solution. So if you don't want to go to the court, you don't know what else you can do. When I started promoting this institution, mediation, because I was trained in 2015, and after that I started doing many things for the promotion of this institution. I had an agreement with the Chamber of Small and Medium Industries here in Thessaloniki, in Greece, and we started to have, in a voluntary basis, we started having a mediation center, and asked and called the members of this chamber to come and be informed about mediation. They didn't know anything about this institution. So, here in Greece, and I think in Italy is the same thing, and in many other countries is the same thing. Lawyers and judges play some huge role about the awareness of the parties, and there is no advertisement. There is no nothing from the ministry that can show to the citizens that it's also other ways of resolving disputes. Only the countries that are that have this culture, like England, UK, or USA, only these places are really promoting this mediation. In Greece, nobody knows. With this law, the final law started to know that there is another way of resolving disputes, and I think I'm optimistic that maybe in 5 years we can have some other procedure. No, for decades.
Yeah, look, well, it all depends on you, Olga. How much you can spread the awareness. Forget the government, forget everything. They're not. We have to think of the government and the courts working only on the matters which are connected to court. But Kenneth had one, connected thing, that if two parties in their contract have a mediation clause, does the court system get involved in that process at all? Oh, is there any connection there?
First of all, in order to put a clause, a mediation clause into a contract, you have to be aware about that. Who is aware about having this clause into the contract? Lawyers are not aware and don't want to be aware, because they think that if they choose mediation, they will lose clients, because the dispute will be resolved very, very quick, and they will have these long court procedures with appeals and all this stuff that are going to gain some fees. So lawyers don't want to put clauses in contracts. The citizens are not aware to ask their lawyers to put such clauses into contracts. So I really I don't think that it. I have seen in contracts. I am almost 20 years a lawyer in practice, and I have seen contracts that have only arbitration clauses and not mediation clauses, and that's bad, because arbitration is a most acceptable institution here in Greece, because it's conducted by professors or former judges, and they promote this institution because they think that it's high quality. And there you can see in investment contracts or constructural contracts, you can see clauses, but for arbitration, not for mediation. And that's really a pity, because you can see, we all know that mediation is a really good and productive institution, and many people can use this institution to resolve disputes very quick and very satisfactory for them.
But Olga, the only people who are saying it's a good method are the mediators. The prospective users are not even talking about it, it seems. So but that we'll get to, because I'm just extension of what Kenneth is asking. Now, supposing there is a clause in the contract and the parties enter into a settlement agreement, is that in any way going to court or connected with court, that aspect of it?
If there is, if we say that there is a clause, then the mediation is mandatory, you cannot go to the courts, and you can go to the courts only for having this mediation agreement. If you have a successful mediation agreement, you can go to the court only for enforceability, in order to register this agreement to the court of first instance, and take this title that helps you to have this agreement enforceable,
But
only for that reason.
No, but enforceable as a contract. Enforceable as a contract, because in India we have a provision for, or we call it, there is a provision for conciliation, and if you go under that, that particular settlement agreement is as good as a court decree. It's as good as a arbitral consent award, and it's as good as a court decree. So there is, we have, in that way we are a little better off there, but not, it's not used. I'm not saying it's used, but it is there on paper. There. But Olga, what about the historical perspective? There is so much, because I'll tell you why I was talking about Christian from Romania who was there earlier today. He has done a lot of research in Crete, the island of Crete. He's gone there and he's researched on those traditional methods that are used in the villages there. And that's very interesting. You must watch that. I mean, very interesting things came out of that. So, I mean, it is all there. It's happening in Greece somewhere. But why is that not coming out?
Oh, I really don't know about that, because what can I say? Really, I'm not aware of that, because in Crete there is something else in Crete. The institution of Sasmos.
Yeah, that's the one. That's the one.
Yeah. This is not in force nowadays. It was happening years ago, many years ago, and it was Crete is quite unique example of resolving problems, because they really don't go to the courts. They resolve them between them in any way. But Crete is something unique, because it's divided from the other Greece. They have their own culture, their own personalities. They trust elderly people. In Crete is a trust of the wise men and women that are old enough to guide them, and that's why it was effective. But it is abandoned during these years, and now I don't think that we can talk about Sasmos and Sastis. It's a great experience, but not using these days.
Know. What I understand from what Christian told us, it is still happening. Okay, as I understand.
Not exactly like that. It's abandoned. It's not so widely happening now. I think that again, Crete is a unique example of division from the other Greece, because they have the vendettas. They have the way of resolving problems, taking the force into their hands. So we cannot talk about this anymore. It's not in force, but it's a way. It's the preliminary of mediation. I think that before mediation, we could have these examples as case studies or something.
But what I'm thinking is that if the whole concept of awareness of mediation, or if it's not practiced or it's not used, is it that now you're coming down from the mandatory aspect and pushing it down? What about what is a traditional method, pushing it up? Is that kind of a movement happening? Can happen? Is Olga going to do that? Is she going to tell people that traditionally people have done this, and the trust in the mediator, trust in the elderly? Have we moved away from that as a society? Now, can we go back to that, or we have to be pushed into mediation by a system which is totally, it's their whole self-interest is there, that their backlog goes away. So how are we going to do this?
I really admire civilizations that have this hierarchy. We in Greece have lost this hierarchy. We don't care about, we're not okay. I must be honest, because I am always honest. If population is not well educated, many things are not clear, and many things are not evaluated as it should be. I mean, we have lost many things in our lives. We have forced by all this. We have been forced by all these obstacles in economical level, or this latest health crisis, and all these things that we cannot depend on what we knew up to now. I think tradition is something that has to come into our lives, but I'm not optimistic that that would happen. I mean, in Greece, the things are really difficult. I don't know if you can understand what I mean. I want to say that I really cannot say many things about that, because I don't want to say bad things about my country, which I adore. But I think that we're not moving into a great direction, and I think that we shall bring hierarchy back into our lives, because if we don't do that, there is no respect for the others. And I think that the main reason to communicate with the others and to resolve problems and to not to create new ones is respect. And since we don't have respect as population, I think that things are really difficult.
But this is, yeah, and this is not, Olga, this is not a Greece situation. This is happening all over the world. And that is why, according to me, we've moved away from a collaborative way of resolving disputes, because society as a structure has changed. People, the way they're looking at relationships within the society, communities, that has changed. So how do we bring that back? Any thoughts? What about the community level? I mean, at community level, is there any work happening on mediation?
We don't have that. I think that in India or in some other places in the world, community is something that really helps, but we don't have that in Greece or in Europe. I think, I don't know. I think nor in Italy, Giovanni. Can you have? No, we don't have. No, I don't think that we have this kind of help, because if we would have, we have other principles. In the European Union, we thought that we could help each other, and we depended all this help upon economical basis and trade and all these things, and we lost the community level and the community aspect of approaching things. And I think that it's very bad, because we lose our identification. If we had all these things that I really admire in India and in other places, as in Israel, I think really would help people to overcome difficulties, and maybe that will be good for mediation too, in order to be promoted and established and promoted. But we don't have such thing in Greece and in Europe, I think, in the whole Europe.
Okay. So now, based on the whatever you presented, Giovanni just wants a clarification that mandatory for less than 30,000 euros. I'm just clarifying, that is what it was, na? Less than 30,000 euros. More than 30,000. More than 30,000.
If you have a dispute less than 30,000 euros, you cannot go to mediation. Not only if you want, but the mandatory session is only over 30,000 euros. 30 and more without limitation.
But the other thing, Olga, is you're saying that for the mediators in that system, it is very strict. They have to go for various training and this, and they have to continue their training programs. But do they do that for lawyers also who have to practice in the courts? Do you have to keep going for that?
Yes, I am a lawyer. I am a mediator and arbitrator too. I don't have limitation because I'm a lawyer. I cannot be mediator or an arbitrator. Of course, if I wasn't a lawyer, I was still capable of being a mediator, not arbitrator, I think. But only mediator. If I would have this training program of 80 hours, in this training program, also some fields of law, as commercial law, civil law, and all these things are taught to the attendees, to the candidates. And after that, we have some oral and written exams in training entities. And after successful exams, we go to the Ministry of Justice and have the same procedure for being accredited, because I may be qualified if I have this training session in training entities, but if I want to be accredited from the Ministry of Justice, I have to pass also this exam. So it's a really long procedure. I mean, you need 80 hours, that is 10 days of training, and you need over 2 months for having all these examinations in training entities and Ministry of Justice. And of course, you have to be trained again every 3 years for 20 or 40 hours. I don't remember exactly.
No, this is what I was asking you. Supposing now that is if you want to practice as a mediator. Now you supposing you don't want to practice as a mediator. You're a lawyer and you just want to practice as a lawyer. Do you also after 3 years have to go for something?
Yes, of course. I'm doing that right now. I'm a lawyer. I'm a mediator. I have been trained, and I'm continuously trained as long as I want to be a mediator.
No, you don't want to be. Supposing you don't want to be a mediator. You're just a lawyer. No mediator, no arbitrator, nothing. Just a lawyer.
Why?
Do lawyers also have to go for this kind of?
Sorry, you're asking. I'm sorry. I'm stuck in mediation.
Yes, exactly.
That's a position. It's not an interest. That's the way that it happens. I mean, the position of mediation. So I'm in the mood of mediation. No, a lawyer. No. If I am a lawyer, I have 4 years of training in the university, of course. After that, I have 1.5 years, almost 2 years of being a trainee lawyer in an office of another lawyer. And after that, I have examinations again in the Ministry of Justice, oral and written. And if I pass this examination, I have the license for
life.
forever. For life,
yeah.
Yes. I don't have to. Of course, it was about before COVID situation. It was the Bar of Association was talking about lawyers being trained every 3 years, and in order to have this lifelong training, etc., for the new practices and new laws, as data protection, as all these things that are new for the lawyers. But this idea is abandoned for now. And I hope that, of course, if apart from the obligatory issue, if you want to be good with your
that's okay. That's okay. That's okay. That's a self-learning kind of thing. But I'm just thinking that we are very strict on mediators, but we are not so strict on lawyers. For what reason mediators have to be pushed into this? And at one point of time, we want to encourage mediation also. I really don't know. But we can get to that. But now, Olga, you haven't touched on the Singapore Convention. What is the situation in the European Union? What is the situation with Greece?
We have not ratified that.
Not signed it also. Have you signed it?
Yes, we have signed it, but not. And I think many countries have signed it, but only 4 or 5 countries.
Six countries. Six have ratified it, and Turkey also has. I think it's a 6-month period, and I think by next year it's going to come into, I don't know, whatever. I think maybe January or something that comes into force there. Yeah.
I think it's the best way that mediation will be promoted as an arbitration that has New York Convention. I think that we have to have this Singapore Convention because, okay, let's say that we have a cross-border mediation, we have a successful agreement. How are we going to enforce this agreement to different places? So I think that this Singapore Convention is the way that we will promote mediation and we will be more confident about being a successful institution. I think that it's a necessity, but my personal view is that European Union is afraid of ratifying that convention. I think that European Union has other I don't know.
Because as I understand, when I look at the situation in the UNCITRAL thing, the Greece hasn't signed it. Greece hasn't signed it.
I think that Greece has.
No, when I look at the official part,
surely not.
Yeah, I think no, they haven't signed. I think the European Union itself, I think they haven't been able to take a decision on that, because this is what the situation is of the signatories. This is the official site there, and that doesn't show Greece has signed it. So I think the European Union, I think, has to come to between themselves, have to come to some decision as to how they have to go about it. I think, which we'll take it up later, I think. So anyway, so I think there is lots that has to happen, but I'm still worried that if we're not going from the traditional route, we are going to this mandatory route, and we are getting the whole concept of mediation from various places in terms of models, and are they successful in those countries? We don't even know that. Has there been a culture of mediation which has developed? So how are we going to develop a culture of mediation in Greece? What are your final words on that?
I think that first of all, it's not it's useless if individuals start doing this effort. This has to be done centrally by Ministry of Justice or by some entities that are approved in the world of trade or in the world of businesses. I mean, chambers or some organizations that really play a huge role in the economy of Greece. As individuals, we are doing our best, but it's not too good to promote this institution. I think that I'm not afraid of. No, I'm not pushed to do something because I know that mediation is here to stay because it's a strategy that is implemented from European Union. So I'm not worried about doing something in order to promote mediation. I know that sooner or later, maybe later, it's going to be promoted either way. because it's implementation from European Union. But I really want to do it fast because that's why I'm trying, and I have this this personal effort to meet chambers, to meet organizations. I speak to everywhere for mediation. I want to do that very, very fast, but I think that either way it's going to be implemented. It's European Union's directive, and so
Okay.
I'm not worried about that.
Okay, now what I'll do is I'll end this with some good words and good words from Giovanni. Giovanni says Olga is a great, great mediator. And that's all that matters. Everything else will fall into place. Main thing is that you're a great, great mediator. And if Giovanni says so, we have to agree and believe that.
No, don't believe it. I want to be tested. I don't want to. I want to prove the qualifications.
No, no, definitely. So thank you very much. Kenneth, of course, has given you that applause. And I mean, it's obviously there's so much to talk about, definitely in terms of Greece or in general. We'll continue that. I'll finish this session, the live session. We can, Giovanni has something to talk about the history part of it. We can have a little